So, fraud relating to property, let's see what these are. So, one is fraudulent removal or concealment of property to prevent its seizure as forfeited or in execution. So suppose an order has been passed by court that certain property has to be seized, and you fraudulently remove it, or so suppose property is fraudulently removed or concealed because there is a court order that says that the property has to be seized or forfeited, then in order to prevent such seizure or forfeiture, somebody fraudulently removes or conceals the property. Again, the intention is important. If it was with a dishonest intention that the person removes it, the person has to be aware of the court order. And if the person is aware of the court order and he still removes it or conceals it, then of course the intention will be presumed. The next aspect, of course, is fraudulent claim to property to prevent its seizures. So, suppose you buy a property which you know is something that is there is a court order that has stated that it has to be seized, or it's part of a court order whereby you if you buy the property you will be as a if you are bona fide then it will help somebody in some way, etc. So all those kind of sometimes people do that, just to create third party interest. Somebody comes in the picture and buys it, so even that person can be charged under the section. Fraudulently suffering or obtaining a decree. So sometimes what happens, just to beat the order, so there's a suit going on, say, with respect to a property, and somebody just gets into another, just files a fraudulent suit against the person, and the person, fraudulently loses the suit just to get a decree in favor of. So suppose there's ABC, A and B. A has filed a case against B. So B will get C to file another case against himself, and then will fraudulently lose the case. So that C gets benefited, and it will cause loss to A. And then B and C will share the proceeds. So that's how sometimes people do. So even fraudulently suffering a decree or obtaining a decree, which she is doing in this case, comes under is punishable. If someone makes a false claim, so first let's understand what a false claim is. Okay, so dishonestly making false claim in court. So if it's done with an intention to injure or annoy, or even if that intention is not clear, someone dishonestly or fraudulently makes a false claim, knowing it to be false. Claim here does not mean just relief. It's not just that you are seeking something that's false. No, that may not be false. Claim could be even a fact on which the relief is based. So, false statement, false claim, more or less it's the same. It just depends where and how you are making it, etc. It may be made in a plain petition or application. It can be criminal. It can be civil proceedings. It can also be made in a, so for a false claim, it need not be on oath. It can be made anywhere. But of course, all these petitions, everything that you mostly file before court is on oath. But even if it's on a note, it's still a false claim then if it is honestly made. It can also be made in a written statement, counter affidavit, or reply, while denying any fact. So it's not just about existence of a fact. If you're making a false claim about non-existence of a fact, then even that will attract this provision. So all those plain denials that happens in the WS, I mean, all of those attract this provision if it's being intentionally, if the person knows it to be false and is yet making it, then it will attract section 209. false charge. Let's see what false charge is. False charge, of course, is only pertaining to criminal proceeding. So if somebody falsely charges a person for committing an offense, knowing that there is no just or lawful ground for such proceeding or charge, then that comes. So this is strictly criminal in nature. Yeah. Forgery. Forgery, section 463 of IPC. Making false documents. So forgery, sometimes we use it casually, or even cheating, forgery. These are the words we generally use. Forgery, in technical terms, would mean making false document, even if it is in part, it still constitutes forgery. It need not always be that you are applying whitener and changing something. It can be just making it fresh. That's also forgery. The intention should be to cause damage or injury to the public or to any specific person. It can also be to support any claim or title. So you want to claim a property, or so you forge a document, a sale deed, etc., or to cause any person to part with property. You want to contest somebody else's suit and kind of say that it's mine, and you are forging a document to show it. The intention can also be to enter into any express or implied contract. The intention can also be, so it can be the basis of, sometimes people enter into contract by showing a certain document, look, this belongs to me. And then it doesn't work out. Obviously, they later on find out. So it can be a case. So it's not necessary. It's not a breach of contract. It's actually forgery. The intention can also be to commit fraud, or that fraud may be committed. So forgery can be done in order to commit fraud. So it will attract both the provisions in that case. Using as genuine a forged document. Using a forged document is also comes under the section that we're discussing right now. Counterfeiting. So again, counterfeiting, if someone's counterfeiting any device, anything that's used to authenticate a document. So suppose you have a false certificate, etc., that people prepare, then even, and that's being used in a judicial proceeding, then even that will come under that.